Thank you very much indeed for that. Again, good morning, everyone. My task this morning, it's a pleasure to be able to talk to you about the Arbitral Tribunal's award on the South China Sea. We've been talking about it all day yesterday, and now we're actually getting to the legal guts of the two awards associated with the Hague Tribunal. My task here is to summarize in the space of my presentation around 700 pages of award. And by the clock, I think I have 3 minutes left if we're going to stick on schedule. So no problem whatsoever there. The outline there is to look very briefly at jurisdictional issues. The award on jurisdiction and admissibility is an award which I think my international legal colleagues will keep them entertained for a considerable time to come, but really to draw out then some of the key findings from the main award and look at some of the implications of those rulings by the tribunal for both within the South China Sea and beyond. Purely on, I must apologize that being a geographer by training, I have, as usual, too many slides, but a fair number of them are maps, which leavens the brew, as it were. But I have done the abuse of PowerPoint, which I criticize my legal colleagues for frequently, and put far too many words on the slide. But what I will, so I won't read all of the words, but what I will draw out is key themes from them. So there are many arguments around the jurisdictional issues for the tribunal and which aspects of the case and the questions raised by the Philippines the tribunal could address. But the sum total of the tribunal's ruling is that the tribunal was satisfied in itself that it could address the vast majority of the questions that were raised by the Philippines. Now, we know that China has declared the outcome of the tribunal and the tribunal's proceeding itself as null and void and without binding force upon it, but it's unclear to me what the international law basis for that pronouncement is. It's up to the tribunal itself to determine whether it has jurisdiction to hear the issues. And in keeping with Annex VII, Article 11 of the Law of the Sea Convention, the award of the tribunal is final and binding and without appeal. Now, we've heard much of the 9-dash line, and one of the key findings of the tribunal relates to the distinction between historic rights and historic waters. And there, the tribunal, I think, has contributed to the progressive development of the law of the sea and international law generally by a reasoning as to how you distinguish between those historic rights and historic title itself. And the tribunal's conclusion was that China, within the 9-dash line, as far as the tribunal can tell, is claiming a constellation of historic rights and not historic title itself. And on that basis, the tribunal could go forward and hear the arguments related to the 9-dash line, and also came to a conclusion that China's historic rights are incompatible with the convention, and that the convention itself supersedes earlier rights and agreements to the extent of any incompatibility. And the significance of this is that it's, I think, an important statement in favor of the primacy of the Law of the Sea Convention and the familiar spatial framework of maritime zones over unilateral claims based on somewhat hazy historic rights. So one might summarize it as EEZ and continental shelf rights, the zonal rights laid out in the convention, they trump, if you will, not a word that we should use lightly in an election year perhaps, but they trump the historic rights claims that the tribunal can discern within the 9-dash line. There was an issue that the tribunal faced in determining the 9-dash line decision, that the 9-dash line itself is ambiguous, as we're familiar with. There's never been a clear articulation on the part of China as to what the 9-dash line truly means, and that left the tribunal with the awkward situation that it had to undertake its own survey of China's practice within the 9-dash line. So it is not inconceivable that China could come forward with new evidence, as it were, that would change that equation, because it was on the basis of the tribunal's own determinations and survey of China's practice, and China was not party to the tribunal's proceedings and could have offered alternative evidence. Perhaps the most anticipated decision of the tribunal was that related to islands and rocks. Not islands or rocks, because rocks, of course, are a type of island themselves, but this is really one of the long-standing conundrums in the law of the sea, and an ambiguity and uncertainty, and this is the first international legal decision of an international court or tribunal that squarely addresses the Article 121 regime of islands issue. Perhaps Article 121 has caused more academic legal ink to be spilt than any other aspect of the Law of the Sea Convention. So this is potentially a very powerful verdict. And the tribunal determined that the term rock is not meant to apply simply to features that are composed of solid rock. It could have broader meaning, that in the assessment of particular features, their natural condition or capacity should be at issue rather than any enhanced capacity, for example, as a result of reclamation or island building activities. And perhaps most importantly or potentially influentially is that the tribunal ruled that in order to have, for a feature to generate extended maritime rights, that is continental shelf and exclusive economic zone rights, then it would either have to maintain a stable community of people, and we can then have some questions about quite how stable and quite how many people need to be involved to achieve that bar, or that there must be an economic activity associated with the island itself, and that is not dependent on outside agency and is not purely extractive in nature. And that's really a fundamental step forward in the interpretation of Article 121. On the basis of that reasoning, the tribunal found that none of the Spratly Islands were capable of more than a territorial sea, and that therefore they are legally rocks for the purposes of Article 121, paragraph 3. Now, the impact of that, combined with the essential elimination of the 9-dash line, transforms the spatial picture, the geography of the maritime claims of the South China Sea. So no exclusive economic zones are generated from islands, no historic rights within the 9-dash line, where they are incompatible with the maritime zones. So instead we have EEZs and continental shelf rights generated from the surrounding mainland and main island coastlines. And another consequence of this is that we will have a high seas pocket created within the central portion of the South China Sea, in line with the ruling. Now, to illustrate this, these couple of slides are, I have to acknowledge and thank my former PhD student, Dr. Andi Arsana. He is from Indonesia, so there is an Indonesian orientation to these slides. But we have the situation prior to the 9-dash line, where Indonesia has delimited its maritime boundaries for continental shelf rights with Vietnam and also Malaysia. And we would have an overlap. And there we have Indonesia's forward position for EZ, water column rights beyond its continental shelf boundaries. And therefore, you have a substantial overlap with Chinese claims within the 9-dash line. Situation after the tribunal's award would look more like this, where we have broad exclusive economic zone rights defined from the surrounding coastlines. We would have still some bilateral overlaps between Indonesia and its neighboring states, but we're also the creation of that high seas pocket within the central portion of the South China Sea, and merely disputed waters out to 12 nautical miles around the still to be determined sovereignty over the actual Spratly Islands above high tide features. The tribunal also ruled on low tide elevations. It subscribed to the earlier ruling of the International Court of Justice in the Nicaragua-Colombia case that low tide elevations are not land territory in the sense that they can be appropriated, that a state can have sovereignty directly over them, although states can still have sovereignty over low tide elevations by virtue of them sitting within a state's territorial sea over which it has sovereignty. The consequence of this ruling in combination with the elimination of 9-9 and exclusive economic zones from islands, is that the tribunal could then say that certain features, such as Mischief Reef, are located within the Philippines exclusive economic zone. They form that LTE forms part of the continental shelf of the Philippines. And as a consequence of China's island building activities there, that action, that practice on the part of China was in breach of the Law of the Sea Convention. So that summarizes that. It should be remembered that artificial islands, in distinction to, as it were, real islands naturally above high tide features, do not possess the status of islands, do not generate the suite of maritime claims from their baselines. And the implication of this is that the island building activities of China on Mischief Reef, they are unlawful as it's building up a low tide elevation on the Philippines continental shelf. And just to illustrate that, and indeed the ruling of the tribunal in relation to China's obligations to protect and preserve the marine environment and failure to achieve that through island building activities and not policing the activities of its fishers, we can illustrate that through some of the wonderful satellite imagery that was mentioned yesterday. And these slides are readily available online, but what I'd like to share with you, and I should declare that I gave testimony before the tribunal in The Hague, so I've had some role within the case. But these next few slides are courtesy of the Philippines team, and they were presented to the tribunal. And it gives a picture of some of the imagery that is, I think, quite compelling and led the tribunal to some of its rulings in relation to artificial island building and the impact on the marine environment. So there we see one of the dredgers grinding up the base of the coral reef flat within the lagoon, creating the material which is then deposited rather than dumped on top of the low tide elevation that is Mischief Reef. So that is an image of Mischief Reef in April 2015 and subsequently in October of 2015. So a very substantial island building activity. And what I can share with you is one of, I think, the more compelling ways in which the Philippines team was able to make its point, because this is a lovely image that illustrates the growth of the island building activity. What the Philippines team did is took an outline of the Peace Palace in The Hague and its associated gardens, which all of the tribunal members wander around at lunchtime, and transpose that onto Mischief Reef, not once, but 40-odd times, in order to illustrate the scale of the island building activity. This is what I call a form of cartohypnosis as a geographer. You can use maps and imagery to your best effect. What I would also say is that this is a close-up image of Mischief Reef in the process of island building. And I think there's an old adage about not building a house on sand. We can see that the sediment plume that smothers the surrounding coral is quite substantial, leaching out of the material that's been dumped on top of the low tide elevation. Very quickly, Subi Reef is another good example of this. This is Subi Reef prior to the island building activity, and that's subsequent. So we have the construction of an airstrip which is 3,250 meters long. Again, 3,250 meters is simply a number to me, and it doesn't fix the idea of the scale of that airstrip in my mind. However, if you then transpose that rectangle and put it over the main runway at Schiphol Airport, where all the tribunal judges are used to flying in and out of, you then create an idea and connection with the judges about the scale of the potentially A380 capable airstrip being deposited on a low tide elevation within the South China Sea. When you're not presenting to the tribunal, you have the sport of judge watching to see whether any of the arguments are actually gaining traction with the tribunal. This particular image, I think, was the most effective in making judges sit up. and take notice. They usually are very good at being poker-faced, but this one really did, it really was an effective way to make the point. And in terms of dispute settlement, the tribunal found that China had aggravated this dispute, not least by undertaking all of the island building activities whilst the tribunal proceedings were ongoing. How am I doing for time, Chris? 5 minutes, fantastic. Well, in terms of the impacts of the tribunal ruling within the South China Sea, clearly China has rejected the ruling. On the other hand, I would believe that the Philippines and other states surrounding South China Sea, Malaysia in particular, also Indonesia and Vietnam, will be emboldened by the ruling, that they will feel that they have the legal justification to undertake activities regarding marine resources, be they seabed resources or particularly fisheries, in those maritime spaces proximate to their mainlands and main island coastlines. So that paints a picture of likely, in my mind, more incidents and raising of tension rather than less. I think China will be keen to continue to assert what it believes are its rights within the limits of the 9-dash line, and we've seen, particularly from Indonesia, but also to an extent from Malaysia, a more robust response, particularly in relation to illegal fishing or fishing activities on the part of Chinese vessels within the 9-dash line, but clearly within what the surrounding states regard as their rightful exclusive economic zones. So I think that the immediate outcome of the tribunal award will be an enhanced tensions, and I think that will be played out more particularly in fisheries than anywhere else. But in the longer term, there is potential for a more beneficial effect, a normative effect on international law generally. And I wanted to close with an example for you, and really this is the audience participation part of the equation, because here we have a feature. There were 2 naturally formed features above high tide and 2 which have been built up. And clearly this looks reminiscent of many of the features we've seen in the South China Sea. This goes to the potential impact of the tribunal's award outside the South China Sea. Would anyone care to hazard where this feature is and what its name is? Johnson, well done. Johnston Atoll, yeah, let's go, which is a US unincorporated territory from which the United States generates a full 200-mile claim in the Pacific there. You can see highlighted with the arrow. It has been gradually built up over time since the immediately post-war period. It's long-standing US control over this feature. It is currently entirely uninhabited. Does this feature have a stable population, one might say? Does it instead have an economic life that is non-extractive, that is one which would pass the relatively high bar that the tribunal has set? So what we have as an intriguing issue going forward is the degree to which this decision of the tribunal and its decision, particularly in relation to status of islands, will actually have some influence beyond the South China Sea, beyond the immediately bound parties for the Philippines and China, whether that will change state practice. And I would suggest that states will be very reluctant to, in a sense, sacrifice what they regard as broad maritime claims associated with their features. And as Australia is in the same boat on this issue, we have distant island features which generate broad exclusive economic zone claims. And if one were to take an objective analysis and an application of the tribunal's decision and the high bar it's set for features to generate extended maritime claims, one would see a substantial contraction of coastal states' claims to maritime jurisdiction from far-flung insular features. And with that, I will thank you.